Welcome, class. Today we are going to discuss an aspect of copyright law, large measure of which has already been covered while discussing remedies in intellectual property law in general. So, you're all advised to watch and read the content covered in today's lecture along with the content of the earlier lecture so that information supplements your present knowledge and this information complements that. Specifically in today's lecture, we are going to look at both civil and criminal remedies. So that is clearly a difference from the earlier lecture where we had spoken only about civil remedies. And also specifically we are looking at the Copyright Act in this lecture and the different provisions contained therein and what the Act has to say about both civil and criminal remedies. But before we embark on a survey of the provisions in the Copyright Act in India and the discussion of its provisions, a more elaborate understanding of what they mean, we need to kind of start with the international conventions, if not anything else, to see the nature of philosophy that drives enforcement globally. Post TRIPS, I don't think anyone would disagree that one can't ignore the international aspects of IP while interpreting Indian law. Of course, we may finally decide to deviate, but even when deviating, the informational base has to accommodate for the international conventions and what they say about any particular issue in IP. The same holds for infringement as well. So looking at remedies for infringement in copyright, the Berne Convention never really had any elaborate remedies, and all it really did was leaving the matter of remedies under Article 5.2 to the laws of the country where protection was claimed. Articles 13 and 16 of the convention did allow for some seizure of infringing copies of a copyrighted work, but it never really had an elaborate mechanism or anything of that sort, resembling anything even close to that. But TRIPS, on the other hand, has been a different animal. TRIPS has had a fairly elaborate mechanism in Part 3 for enforcement of IPRs. Article 44 authorizes judicial authorities in member states to pass orders of injunction restraining parties from committing acts of infringement, including importation of infringing goods, such that the channels of commerce are kept free of these goods. Article 45 of TRIPS again authorizes authorities to order payment of damages adequate to compensate for the injury the right holder has suffered because of an infringement of his intellectual property right by an infringer who knew or had reasonable grounds to know that he was engaged in infringing activity. So, both the remedies of injunction and damages are envisaged in TRIPS in Part 3. When we go on to look at Section 55 of the Indian Copyright Act, we realize that the model of imposition of damages against parties who had reasonable belief of themselves involving in an infringing activity has been present in the Indian Act since 1957, way before TRIPS came into effect. So in that sense, one could even say that the Indian Act took a lot more progressive view of infringement than many of the international conventions. But before we get into that, let's quickly see the other provisions in TRIPS as well. Article 46 is an important provision because it authorizes member states to allow judicial authorities to order the destruction of infringing goods as well as materials and implements used to create them without payment of any compensation. Again, the whole idea here is that once there is an intellectual property right vested in an individual, all the property, including goods, that make use of the IPR in question are technically the property of the owner of the IPR. So when these goods are created, unless judicial authorities have the power to confiscate these goods and destroy them, the fruits of the infringement will lie in the hands of the infringer. So Article 46 specifically targets that problem and seeks to redress it by authorizing judicial authorities to destroy. Article 50 of TRIPS provides for various provisional measures, and most of it is of the kind that we have already covered in the earlier module on remedies in intellectual property law. Then we have Article 51, which also provides for border control measures, again an important provision, which authorizes member states to adopt procedures enabling a right holder to apply to the customs authorities of that state for the suspension of imports that he suspects would infringe his IPR. In this situation, all that the right holder has to do is to provide adequate evidence that there is prima facie an infringement of his intellectual property right, and of course he has to supply a sufficiently detailed description of the goods to make them readily recognizable by the customs authorities. The customs authorities can then demand security from the right owner, which is sufficient to protect the interests of the alleged infringer, and this is obviously to protect against a situation where if later it is shown that the goods were wrongfully detained, the importer can be indemnified. So this is a pretty interesting mechanism, and the Indian law again has provisions of similar effect. This is provided by way of the Customs Act and circulars under the Customs Act. Then coming to criminal remedies, again it shows the level of detailing that has gone into TRIPS, at least when it comes to the area of remedies, because Article 61 is a pretty elaborate provision which reads as follows in respect of criminal remedies. It says, members shall provide for criminal procedures and penalties to be applied at least in cases of willful trademark counterfeiting or copyright piracy on a commercial scale. So the attempt of the law here is to make a distinction between commercial and non-commercial violations of IPR. The provision goes on to read, remedies available shall include imprisonment and or monetary fine sufficient to provide a deterrent consistently with the level of penalties applied for crimes of a corresponding gravity. In appropriate cases, remedies available shall also include the seizure, forfeiture and destruction of the infringing goods and of any materials and implements the predominant use of which has been in the commission of the offence. Members may provide for criminal procedure and penalties to be applied in other cases of infringement of IPRs, in particular where they are committed willfully and on a commercial scale. So again there is an emphasis on commercial scale and on willful acts of infringement. And the power of the court, similar to what we had seen in Article 46 with respect to destruction of material by judicial authorities, destruction of goods. Here destruction of all the methods, materials, implements, all of which is used for the commission of the offence. There is power to seize, forfeit and destroy such materials and infringing goods as well. So these very many important ideas combine to send out the strong message that TRIPS as a treaty believes in strong enforcement, and that without strong enforcement IP is virtually of no value. If you really need intellectual property rights to have any real value in the market, then of course you need to provide for strong enforcement measures. So with these broad ideas and brushstrokes of what the international conventions provide in respect of enforcement, we can embark on a survey of the Indian Copyright Act. Now the major questions to be addressed are, apart from the nature of the remedies, who can initiate these proceedings? Against who can such proceedings be initiated? Where can you initiate these proceedings? These are all procedural matters, but of great significance to the way in which IP is enforced on the ground, and great significance to the signaling effect in terms of what we as a society send out as a message to those who choose to violate IP. Any discussion of the provisions in Indian law, in the Indian Copyright Act, dealing with remedies has to inevitably start with section 55. 55 outlines the civil remedies for infringement of copyright and reads as follows: where copyright in any work has been infringed, the owner of the copyright shall, except as otherwise provided by this act, be entitled to all such remedies by way of injunction, damages, accounts, and otherwise, as are or may be conferred by law for the infringement of a right, provided that if the defendant proves that at the date of the infringement he was not aware and had no reasonable ground for believing that copyright subsisted in the work, the plaintiff shall not be entitled to any remedy other than an injunction in respect of the infringement, and a decree for the whole or part of the profits made by the defendant by the sale of the infringing copies, as the court may in the circumstances deem reasonable. So subsection 1 of section 55 clearly provides for all the different remedies that we have discussed thus far, such as injunction, damages, accounts, and so on, and also contains the same principle that we had seen in the TRIPS agreement, wherein a defendant is not liable for payment of damages unless he was of the belief reasonably, or would or ought to have had the reasonable belief that copyright subsisted in the work which he is now alleged to be infringing. Apart from section 55, there is an important aspect of the right to sue which one may keep in mind, which is that there is no presumption of ownership except where one has obtained a registration of copyright. So the fact that you have registered your copyright, while not determinative of you enjoying the right, because copyright protection, unlike patent protection, is not dependent on the fact of registration. Yet the fact that it is registered offers you a presumption of ownership when you sue the defendant. Of course, it is for the defendant to rebut the presumption, but on the face of the record, because you are mentioned as the owner in the register maintained by the Registrar of Copyright, you are presumed to be the owner unless proven otherwise. So once we have this sense of the landscape in terms of the remedies and the presumption of ownership, it is best to quickly look into the different categories of people who can sue in respect of infringement of copyright. So the first important category is, of course, the owner. Now normally, because of section 17 and the presumption that authors are the first owners of copyright unless as otherwise provided in that provision, authors in their capacity as first owners joint owners of copyright, again, a situation where both parties collaborate with the intention that they shall both jointly own the copyright in respect of that work. Then producers or employers who become first owners, valid assignees of copyright, that is those who take the copyright from the initial owner or subsequent owners based on an assignment deed, which is a deed for the transfer of the copyright. Exclusive licensees and copyright societies. Now, exclusive and non-exclusive licenses are just two categories of licenses. So, non-exclusive license is where any party other than the present licensee can also be granted a license by the licensor. So, there is no bar on the licensor from granting multiple licenses. But an exclusive license is one where, at least in respect of that particular exploitation of copyright, the right shall exclusively vest with the specific licensee, and there is a bar on the licensor from granting a license in respect of that particular use of copyright or the copyrighted material to any other licensee. So, in respect of a film, for instance, one party may be given an exclusive license to remake the film in language X, another in language Y, and a third in language Z. Normally, where there are exclusive licensees, the exclusive licensee can sue, but the law requires the copyright owner to be impleaded as a defendant. One of the reasons for this is that there is a statutory bar on the copyright owner under section 61(2) from instituting any fresh suit or proceeding in respect of the same cause of action. So, because there is such a bar, it is only fair that the copyright owner is heard in the other suit which is instituted by the exclusive licensee. As far as copyright societies go, interestingly, the Act is vague about their right to sue. But in a decision of the Delhi High Court in Phonographic Performance Limited versus Hotel Gold Regency, the division bench has held that a copyright society can initiate a suit for infringement, and that too without complying with the provision for impleading the copyright owner. So this is a very interesting sort of verdict where the court has really looked into the purpose behind creating a copyright society in the first place. Now, copyright societies are nothing but societies which have been created for the collective administration of rights of various copyright owners of different classes of works. So, the copyright society would be representing a class of works, like for instance in the case of sound recordings, the Phonographic Performance Limited is the copyright society under the Copyright Act, and which in turn administers the copyrights of sound recording labels which are members of the society. So what the law says pursuant to Phonographic Performance versus Hotel Gold Regency is that if you are a copyright society, you don't need to implead the owners of copyright as part of the suit, and you can independently file a suit against the defendant, and you can claim damages and you can get an injunction and so on and so forth. So these are the different categories of actors who can sue for infringement of copyright, and the various nuances, at least some of the important nuances which the action entails. Similarly, an interesting issue is who can be sued. Now here the most important category of those who can be sued, which needs or merits discussion, is the prospect of suing unknown infringers. Now today we have come to a stage where the moment a film is released in 2 or 3 days, or sometimes even earlier, copies of the film, and reasonably watchable copies, one could say, are available on different BitTorrent sites or sites that make use of the BitTorrent software. And easily people can download it, watch it, as a result of which there is little interest in venturing out of home to a movie hall and watching the movie. And the same is the case with books. With a lot of content, that online piracy is at an it's today capable of really impacting considerably the revenues of the physical channels of distribution, the authorized channels, so to say. So then the automatic question is, when there are many of these individuals who are committing infringement, whether it's online or even cases of trademark counterfeit goods, for instance, or in copyright, pirated copies, hard copies of the book being sold by different vendors outside a railway station. So in all these cases, the real challenge is enforcing your IPR. Can you sue each of these infringers independently? Is it even practically viable? The answer is of course not. It's not. It's not possible, especially in the case of online piracy, even otherwise. So one of the interesting remedies that has come about, and the history of that is traced in the course material, so you can go through that. Right from the day of Billy Joel versus various John Does to the present day, where the court is also seriously contemplating or has already performed the laying down of checks and balances of the passing of such orders as well, because sometimes they can take an excessively harsh and unbridled tone and tenor. So from then to now, there have been instances, and these serve as precedents today for us, where the court allows the plaintiff to file the suit against known and unknown infringers, and the unknown infringers are in turn listed as the various John Does. So this has come to be known as the John Doe Orders in IP. So the purpose of these John Doe Orders is to bring to the table those unknown infringers. And how does the law seek to do that? It does so by way of the grant of an interim order already against these guys, and when they are detected or found infringing, the interim order is immediately served on them. So the prohibition applies from the moment they are found, the moment they are caught. There is an interim order served and there is a prohibition on them. So if they were to sell it from that very moment, they would be liable for contempt of court. So this is the way the law is enforced, by making them liable for contempt of court the moment the act of infringement is carried on and they are discovered in the process of doing so, and by virtue of an order of injunction which is already present against all unknown infringers. Now what do they do? What is the solution for them to get over this predicament? Well, if they feel that they are licensed, or they feel that they are justified in doing what they are doing, whatever may be the reason for that, then of course they can approach the court of law and they can seek to vacate this order of injunction which has been passed against them. Of course, it's a different matter that most people will not do so, because many of these are not anything but eyes open infringement cases. So there is no possibility of any justification for that conduct, legally speaking. So it is a pretty interesting mechanism, as long as it is not abused to the extent where people go search, seize equipment and so on, and harass others while in their business. Doe orders can be pretty effective in enforcing copyright. Today, of course, we have come to a situation where Doe orders are largely used in the case of online piracy. With several films recently, Doe orders have been used, and pretty effectively, for the reason that the Department of Telecommunications and the different internet service providers are the ones implemented as the known parties in the proceeding. So the idea is, in some sense, to enforce the order against these unknown online pirates by resort to the mechanism of the ISPs and the DOT. It seems to have some effect and is in any case a fairly practical way of implementing and enforcing the law. The next important aspect of enforcement is the special rule regarding the place where one can institute a suit. Now, under the normal rules of the Civil Procedure Code, the suit can be instituted either in a location where the defendant resides or carries on business, or where the cause of action arises. But interestingly enough, with copyright cases of infringement, the law provides for an additional forum, and this additional forum is the place where the plaintiff resides or carries on business. The reason this has been done is again to make enforcement of intellectual property rights more effective. Basically, the plaintiff does not have to run to the place where the defendant carries on business. Moreover, in many cases, the cause of action would arise elsewhere, because the defendant, being located in Bombay, might decide to sell infringing copies of the plaintiff's IP protected work in Bombay, while the plaintiff might be running operations from Calcutta. So today, the law, by way of this provision, allows the plaintiff to sue in Calcutta in addition to Bombay, where the cause of action arises, or Bombay where the defendant carries on business. The plaintiff can also sue in Calcutta, where he or she carries on business or resides. So this is definitely a beneficial provision and has been used quite often to expand the jurisdiction of courts and make it convenient for the plaintiff to sue the defendant. In addition to the various remedies granted to the owner of copyright for infringement, the Act also provides for a civil remedy to one who is threatened with an act of infringement allegedly to be committed by that person. So this is called a groundless threat, or a suit for groundless threat, an action for groundless threat. The provision, section 60, reads that where any person claiming to be the owner of copyright in any work by circulars, advertisements, or otherwise threatens any other person with any other legal proceedings or liability in respect of an alleged infringement of copyright, any person aggrieved thereby may, notwithstanding anything contained in so and so provision, institute a declaratory suit that the alleged infringement to which the threats related was not in fact an infringement of any legal rights of the person making such threats. So the basic message from this provision is simply this, that if a person has been accused of infringing someone's intellectual property rights, that person can institute a suit to declare that the alleged infringement which he is accused to commit is not in fact an infringement of any of the legal rights of the person who is making that threat. So the declaration can entail also a finding of no intellectual property rights at all being enjoyed by that person. However, this provision does not apply if the person making the threats has commenced with due diligence an action for infringement of the copyright claim by him. So if the moment there is a suit initiated by that person, from that moment the right to institute an action for or an action against groundless threats does not apply. The last part of our discussion on the various civil remedies deals with delivery up and ant and pillar orders. We have already seen ant and pillar orders largely in the context of general remedies in intellectual property law. Section 58 specifically deals with delivery up and says that all infringing copies of any work in which copyright subsists and all plates used or intended to be used for the production of such infringing copies shall be deemed to be the property of the owner of the copyright, who accordingly may take proceedings for the recovery of possession thereof or in respect of the conversion thereof, provided that the owner of the copyright shall not be entitled to any remedy in respect of the conversion of any infringing copies if the opponent proves that he was not aware and had no reasonable ground to believe that copyright subsisted in the work, or that he had reasonable grounds of believing that such copies or plays did not involve infringement of the copyright in any work. So the whole idea of this provision is to take further the proprietarian assumptions underlying copyright. As we already saw earlier, property absolutism and essentialism are key to at least certain conceptions of copyright, which believe that once you are the owner of copyright, it is as good as your rights in respect of what you enjoy in the physical world, like your pen or your book, where you have absolute control over what you need to do with your property. An extension of that is the fact that if somebody makes a copy of your work without your permission, an infringing copy basically, or were to use material to make such copies, then all of that will also be colored with your property. So they all basically get the stamp of the same proprietarian assumption that makes your intangible property, your creative effort, yours. The same stamp applies or extends to infringing copies of your work that have been made by others but without your permission, or material that is used to make such infringing copies. And in such case, the court has the power to also confiscate these materials and destroy them, which is a separate power. But the idea here is that the copyright owner can assert his property right and thereby recover the possession, or basically take the possession of these infringing copies and plates and so on and so forth. With this, we come to the end of the discussion on civil remedies, and we'll quickly take a look into the various criminal remedies. As we have already seen, criminal remedies place a lot of emphasis in TRIPS, at least, on the willful infringement aspect, and the same is reflected in our Copyright Act too, though some of the provisions, as already mentioned, have come or were in force from the beginning and come or predate the TRIPS provisions. So section 63 incorporates the principle of willful infringement and seeks to impose criminal liability only on those who knowingly infringe or abet the infringement of copyright. The punishment is stipulated to be anywhere between 6 months and 3 years. And it is interesting to see that the dimension of commercial versus non-commercial infringement, which we had seen in the context of TRIPS, is also factored into the sentencing under the proviso to section 63, which permits the court to go below the lower limits for both imprisonment term and fine in cases where the infringement has not been made for gain in the course of trade or business and for adequate and special reasons that are mentioned in the judgment. Another interesting issue that has come up in the context of section 63 is whether the owner of the original copyright should come forward in a criminal action to initiate the action. In this regard, the Supreme Court has in fact pronounced in State of AP versus Nagoti Venkataramana and has clearly held that the idea of criminalizing under section 63 for willful infringement was largely to address the threat of video piracy. And in all these cases, there is no need to trace out the owner of the copyright. The state can initiate and continue the prosecution without the owner being present. Again, as to the issue of whether the offence under section 63 is bailable or not, as is mentioned or highlighted in the material circulated, there is a fair bit of confusion. Some cases hold that it is a bailable offence, while others hold that it is not. Section 63B of the Act criminalizes the knowing use of an infringing copy of a computer program on a computer. So this provision is interesting because the use of content that is downloaded from the internet, especially private use and so on, is not criminalized in Indian law. There is nothing illegal about, or there is nothing criminal about copying files onto your hard disk via torrent and watching it in your home. You may be committing an act of reproduction and thereby technically civil infringement, but not criminal. But section 63B says that the knowing use of an infringing copy of a computer program on a computer is a criminal act, and the large part of the reason for this comes from the fact that most of these infringers are commercial entities, people who want to save on the cost of the commercial license and therefore may be either using an illegal version altogether or a personal use version but in a computer meant for commercial purposes in their commercial place of business. Finally, we come to section 64, which vests power with the police to seize without warrant infringing copies and plates that are used for committing infringement. Such infringing copies and plates can again be handed over, and the magistrate can then order the delivery up to the copyright owner of all the copies of the work and the different plates and so on, because as we already discussed in the context of section 59, there is a proprietarian assumption here, and 58, I'm sorry. The assumption is that the property belongs to the owner of the copyright. So these are the important remedies, both civil and criminal, for enforcement of copyright, and with that we come to the end of the discussion in this module. Thank you for your patient and kind attendance.